All right, we're going to call the meeting to order. And at this time, well, first let me see if are there any bill introductions. All right, we'll move on. We're going to rearrange our schedule a little bit. We're going to have a hearing on Senate Bill 88, clarifying the vacation or exclusion of territory from city boundaries or release of easements. We have Amanda Staley, General Counsel for the Kansas League of Municipalities, that will be speaking. But before that, Jason would, we're not, where's our?
I don't know where the tablet, oh, there.
Just a second. Might help to have everybody else on. Right, I know, but I need Jason. How come they're not up on the screen? I know, but how come they're not up on the screen? Okay. I don't even see. Is Jason on? All right, we cannot see that anyone's on the WebEx. If you are, could somebody please respond?
This is Amanda Stanley. Senator McGinn, can you hear me?
Okay, yes, thank you. We're going to have Jason explain the bill. You guys are finally popping up. So, Jason, would you just give us a quick overview on Senate Bill 88?
Yes, Madam Chair, members of the committee, Senate Bill 88 proposes clarifications to the procedure under which a city can vacate or exclude land from the boundaries of the city. The bill amends 12-504 to distinguish between the process of a landowner petitioning for a vacation or exclusion of land and the city initiating a de-annexation of land. The notice and hearing procedures would be the same under both processes. The bill also amends 12-505 to clarify the conduct of a public hearing that's required for this action. And then finally, the Senate Bill 88 would create a new section of law to provide landowners with a cause of action against the city if they are aggrieved by any decision of the city to vacate or exclude or de-annex land or improve or vacate street improvements. The bill will go into effect on July 1st of 2021, and I'd be happy to answer any questions.
Any questions for Jason at this time? Thank you, Jason. Next, we'll go to Amanda Stanley.
Thank you, Senator McGinn. This is Amanda Stanley, and I am General Counsel for League of Kansas Municipalities. I appreciate the opportunity to provide testimony today on Senate Bill 88. This bill was first introduced during the 2020 legislative session as House Bill 2583. Ultimately, it passed overwhelmingly in the House. It came to the Senate. It passed out of this committee last year, and then unfortunately, the world shut down due to COVID-19 and session abruptly ended. So we're back again this year, asking you to pass this legislation. And the goal of this legislation is simple. It's not to change any of the procedures when a city vacates a street. The goal is to clean up the statutory language to make it clear and easy for city officials and citizens alike to understand the process. So the procedures that cities have used to vacate streets have been largely unchanged for more than 100 years, and they've worked well for more than 100 years. Each class of city has its own procedure to follow, and those are each in statute that I reference in my testimony. Just to clarify what the revisor said, this does not create a new cause of action. There's already provided in each of those individual cities an opportunity for citizens to go to the district court. So there isn't a new cause of action. It just clarifies where it's at. In addition to the procedures used when a governing body would like to vacate a street, the legislature has created a process for when a citizen wants to request a street be vacated. So for example, let's say they've bought up several lots and the property has changed and there's no longer a need for a street. A citizen and a landowner could come petition a city to say the street no longer needs to be here. We'd like it to be vacated. That procedure is what is contained in 12-504. From the legislative history we can find, prior to 1967, this statute was solely used for when a landowner wanted to petition for a street to be vacated. For some reason, in 1964, the legislature decided to make things slightly confusing and added language into this statute, seeming to imply that a governing body could also use this procedure to vacate a street. That change has never made sense. Under the statute as written, the governing body would submit a petition to the city clerk asking for a street to be vacated. The city clerk would submit a petition right back to the same governing body asking them to vacate the street, and then that would start the process. under the rules of statutory construction, when there's more specific statutes, those control over the general. And so cities have continued to use their more specific statutes when they would like to initiate a street vacating since 1967. In 1984, the legislature added additional confusion by modifying the statute to state that that's the one that the governing body of a city is to use when it wants to initiate a de-annexation. So after more than 50 years of confusion, we thought it was maybe time to come ask this body to clean up this body of law and make it clear how these processes are supposed to work. And I guess fundamentally, I'm here before you today because as a lawyer, I truly believe that the law should be written in a way that we can understand it, and that you shouldn't have to sentence diagram a statute to be able to follow it. And so we're not asking you to change the policy behind the law. We think the law works great. We're just asking you to rewrite it so that it's easy to understand what this law does. And then finally, when we were doing this process, it was brought to our attention that there's no statute of limitations on when to bring a claim that you have been penalized or that you've been aggrieved by a street vacating. You can already bring those claims in each of the classes of cities. Cities of the first class, cities of the second class, cities of the third class. However, there's no statute of limitation on when those claims can be brought. So it was suggested that it would be prudent to add a statute of limitations for when these claims can be brought so that the landowner deserves certainty that once this land has reverted back to the landowner, that they won't then have a claim be brought 5-6 years in the future. So this provides certainty to the landowner when that land has been reverted back to them that the street is going to be vacated. So that's why I'm before you. I'm happy to answer any questions. But at the end of the day, I'm just asking you to help make the law a little bit more clear so that everyone can read it and understand what it means. Thank you.
Thank you, Amanda. Are there any questions for Amanda Staley at this time? Any questions? I don't see any, Amanda, so thank you. Did you have questions, Senator?
I was just kind of spitballing here. And on page 2, line 9 through 11, any city may initiate the de-annexation of land from the city. So the public hearing process would be how any landowner who did not want to be de-annexed would be able to fight back. I don't know if that ever happens. I'm just curious.
Yes, Senator. This has been the law since 1984, so it's been in place for, I guess, longer than I've been alive. De-annexation happens very rarely. Occasionally it does. Generally it happens when a citizen says, hey, the city's changed so substantially that my land no longer makes sense to be in the city, and the citizen initiates it. I don't know that I've ever seen a city de-annex, but I didn't want to change the public policy in case there was a need for it, since it's been in law for 30 plus years and seems to work.
Okay.
But so
Thank you, Madam Chair. Thank you, Amanda. Appreciate it.
Senator Warren?
Thank you, Madam Chair, and thank you, Ms. Stanley. Does this apply to when a city decides to no longer maintain a city road?
Street vacating, yes. So when a city decides that a city road no longer is appropriate and it vacates it, it reverts back to the original landowner. Those statutes are 13-443, 14-423, and 15-427 is when a city initiates it. This is when a landowner is asking a city to vacate it, so that it's making it clear which process you're supposed to follow. If you're a landowner, you follow the statute. If you're a city, you follow the specific statutes that you provide publication, you provide notice, you provide an opportunity for hearing, and then you have certain things to follow.
Thank you. If I could have one more question. So when the private property owner initiates, they don't want the city to maintain the city road any longer. Are there notice requirements for the public for that as well?
Correct. That's 12-505. And so that is the following statute after this one. So this says when a citizen wants to initiate it, they submit a petition to the city clerk. It then has a hearing, notices provided out to all the adjoining landowners, and then 505 gives neighboring landowners an opportunity to veto it.
Thank you, Madam Chair. Thank you, Ms. Stanley.
Any other questions? All right, I don't see any, so thank you. Do we have anyone else that would like to speak as a proponent to Senate Bill 88? Anyone else? Anyone like to speak as an opponent to Senate Bill 88? Anyone like to speak to Senate Bill 88 as a neutral? Seeing none, we'll close the hearing on Senate Bill 88. time, we'll turn our attention back to Senate Bill 52, creating the city or the Sedgwick County Urban Area Nuisance Abatement Act. I believe where we left off is that we needed to have some amendments distributed. I think Jason has been now receiving the amendments as needed, and so we will continue that process. And, well, actually, I think, Jason, I'm just going to have you give us an overview of where we left off and go over the amendments that were adopted and the amendments that were still hanging out there, if you would, please.
Okay, Madam Chair, members of the committee, last week the committee adopted balloon amendment number 1, which struck the last sentence at the top of page 2 that referred to service on a non-resident. It also clarified that the personal service to be served on the owner there at the top of page 2 was to be done in accordance with 60-303, which is the civil action personal service statute. The next amendment that was approved was amendment number 2. And I actually have redone amendment number 2, and it can be distributed to the committee. This was the amendment that struck the words "or agent of the owner" throughout the bill, added language at the bottom of page 2 that all orders and notices are to be served on the owner of record, and also struck language at the top of page 2 referencing the certified mail service, because that type of service is covered by the personal service under 60-303. And then finally, the committee adopted a balloon amendment number 3, which added a new subsection at the end of section 2 that any decision by the Board of County Commissioners is subject to the Kansas Judicial Review Act.
Any questions for Jason? Thank you, Jason. Senator Pascudo.
Thank you, Madam Chair. Jason, just for clarification, on line 10, that paragraph there, as it states, from such nuisance within the 12-month period to address this issue. So is that retroactive? Does that start again after this legislation is passed? Or can you just explain that paragraph?
Yes, Senator, what that is saying is that there must have been a conviction for a county code violation within the past year prior to the issuance of any abatement order by the Board of County Commissioners. So if they're going to issue an order to abate and remove a nuisance, that had to have gotten a conviction for a violation of the county code within the previous 12 months.
Senator Warren.
Thank you, Madam Chair. Jason, I had a question about amendment number 3, and when we refer to the Kansas Judicial Review Act, have we referenced the right part of statute by the Kansas Judicial Review Act when the intent of the amendment was to get the review of the decision of the county to a district court, and to a district court judge, not an administrative hearing judge? Have we referenced the right part in the amendment to get it to the district court?
Typically, when we put in statute review by the courts of an administrative act by some governmental entity, we do refer to the Kansas Judicial Review Act and the procedures that are laid out in that act for appealing an administrative decision.
So does that get the property owner into district court, or does that get reviewed by an administrative law judge, with the way the amendment's written now?
I believe it gets them into district court. I believe the Kansas Administrative Procedure Act is the act that we do for appeal first through an administrative law judge.
Okay, I'm just wondering if the intent of my amendment was to get them in front of a district court judge if they decided to appeal the decision of the county, and I'm wondering if we've done that in the amendment.
You have. The Judicial Review Act is to get into district court.
Okay, thanks for clarifying that.
Senator Thompson.
Thank you, Madam Chair. Thank you, Jason. On line 15 of page 1, Board of County Commissioners may order removal or abatement of any nuisance. I don't see any definition of nuisance. I mean, I understand it could be, I understand the intent of this bill, but that's awfully broad and awfully open to objective or subjective consideration. So I don't know, how do we deal with that?
Senator, first, I'll direct your attention to Section 5 of the bill on page 3 excludes agricultural purposes. Any land, structure, machinery, equipment, motor vehicles used for agricultural purposes are not subject to this act. So any of those types of land or equipment that would create a nuisance are not subject. The other thing on page 1, right above the language you were pointing out, is the county first has to obtain a conviction for a county code violation. So nuisance is defined in the county code, and what constitutes a violation of that code as being a nuisance is in the county code, and you have to have a violation of that and a conviction for a violation before the county can proceed with any abatement process under this act. So nuisance is defined locally by the county as to what would constitute a nuisance.
Okay, so if another county decided to take up a similar type of bill, we could end up with a patchwork of inconsistencies about what nuisances are all across the state. I understand this is with urban areas, but cities could probably do the same thing. My concern is property rights, obviously, and I'm just trying to make it as narrow as humanly possible.
And Senator, I'll just point out that many municipalities have adopted their own codes with their own definitions of what constitutes nuisance in that jurisdiction already. And so it does vary from municipality to municipality.
Thank you, Madam Chair.
Cities are already doing this.
Okay.
All right. Senator Straub, you want to go first? Senator Warren.
Thank you, Madam Chair. Jason, just to follow up on Senator Thompson's questions, Section 1C and then Section 2A. Section 2A looks like the county commissioners can, by resolution, determine that there's a nuisance. Is that different than the procedure of finding a county code violations for nuisance in Section 1C?
Yes. First, there has to be a conviction for a county code violation under the county's due process for violations of the county code. And once that is obtained, then the Board of County Commissioners could adopt a resolution that issues an order requiring the nuisance to be removed or abated. So there are two separate actions.
So two separate options, section 1C and section 2A. First, in section 1, you've got to get a county code violation for a nuisance, and section 2A, the county could by resolution determine it's a nuisance. Do I have that right?
Well, it's a two-step process. First, there has to be a county code violation conviction against the property owner that a nuisance is present and violates the county code. That's the first step. And once that's obtained, then the county commissioners can adopt a resolution to issue an order to abate that nuisance. So it's a two-step process. You have to have one and then the next one.
Thank you. I thought that was the case because section 1C does say before any nuisance abatement process shall be commenced under this act, the county has to have a county code violation for a nuisance.
That's correct.
Thank you. Thank you, Madam Chair.
Senator Straub?
Thank you, Madam Chair. I just also want to concur with Senator Thompson on those comments that I made last week, that my main concern is private property rights, and if there's an area that's close to city limits, you know, there's always the option of annexing those properties and making them part of city code. I do worry that this solves a specific issue in this urban area, but I worry about the unintended effect on private property rights in further outlying rural areas of that county, and also, does it set precedents for the rest of the state?
Senator Haley?
Along that same line, Madam Chair, I'm wanting to ask Mr. Long if he'll help me to better understand, or us to better understand, if this were left up to me, because I just don't understand why we're here at this level. If this is a specific concern of one county, of Sedgwick County, why is it being put in state law? As has been mentioned, I'm concerned. If this were for Wyandotte County, which is my county, I would not be supporting it. But if it's Sedgwick specific, and if you can keep the state law in your county, as far as I'm concerned, Madam Chair, if this were left up to me, since it's your county, only you and Senator Falscadeau and Senator Erickson should weigh in. But the rest of us here from other parts of the state, other than Sedgwick County, are being asked to opine what's good for your county specific. So my question for Mr. Long is, what protects, in this language, what protects us from seeing this grow beyond? How does another county or another area grandfather themselves potentially into this particular law? I'm looking at the end of it. I know it says Sedgwick County, but I'm just, why are we here? You know, if it's only Sedgwick County specific.
Question for me or for Jason?
For you and or Mr. Long, whomever.
We're here because Sedgwick County requested it, and,
Yes.
They've made it Sedgwick County specific, so that and they've made it urban county specific. And it's because Sedgwick County has 20 cities, and we have a lot of people who go annex all the good stuff and leave the parts that doesn't bring in any revenue. And these are the areas that they cannot try to clean up if needed. Look at the bill. There's several processes that happen before they can actually even clean this up. So I think it's more of a long-term problem that they evidently felt like they needed to change the statute, and they are addressing themselves only in order to do this. If your county wanted to come in, you'd have to wait another year or amend this to include Wyandotte, but you would have to amend this bill or this statute at some point in time in the future, because otherwise they're not in it.
So, Madam Chair, why can't the Sedgwick County Commissioners alone, and I think at some point in time you were a part of that process, why are they alone not able to implement these provisions for the benefit of Sedgwick County and all of the municipalities there?
Well, I think if they could do it alone, we wouldn't even be having this conversation. So I think I'll turn, I heard that Chris Laham, I believe, from Metropolitan Planning is on the WebEx. Chris, are you there?
Yes, Madam Chair, I'm here. I've also
Chris.
got our Assistant County Counselor, Justin Wagner, is on as well, who could speak to this. So the county, there was abatement powers, or were abatement powers in the past. An abatement code was in place, and multiple counties had those. But there was Cali County, I believe it was, a case in which that was challenged in court. It was upheld, and based on that ruling, we are all of those new abatement codes were rescinded. Justin, sorry, do you want to add to that?
Yeah, this is Justin Wagner, Assistant County Counselor, Madam Chair, and members of the committee. I would supplement what Chris Labrum just said. In 2012, there was an opinion from the Court of Appeals that said the county home rule powers are not sufficient to order the abatement of nuisances on properties and cannot allow for any of the costs on the cleanup to be assessed against the properties. And so there's no explicit power under county home rule to do that. And there's no statute that specifically authorizes the county to do that. So as Chris mentioned, Sedgwick County, we got rid of our nuisance abatement provisions because of that court opinion from 2012, whereas this bill would give Sedgwick County only the ability to take a nuisance abatement approach as indicated in the bill.
Senator Haley, did you have a follow-up?
I'm trying to digest exactly what that would mean by way of application from some other county. If they too in Sedgwick have abated their relevant statutes and now are seeking state relief, what then would be the process other than this for another county to fall prey? Well, not fall prey, that may be, well, to follow suit. Like my county, Wyandotte County. Johnson County has, I think, 22 cities, for example. If you want to keep it in Sedgwick County, I'm good. I just wonder
That's what the bill does.
what precedent
in
this
Sedgwick
sets
County.
for some other county that may not be as anxious as Sedgwick to do it.
Yes, they're not in. Senator Straub.
Thank you, Madam Chair. I understand the comment from Mr. Wagner about them getting rid of their new codes, because I believe under state statute that any type of actual public health, safety, or welfare issues can be remedied through KDHE currently. So the issues that it seems that Sedgwick County is having are more nuisance issues and not actual public health, safety, and welfare issues. So there lies my main concern in passing this, is because we currently have statutes in place to protect public safety, and a nuisance could be noise that an animal makes, or motorbikes, or chipping paint, or I don't know, trees that have grown out into, over a neighboring property or something. So things get real dicey if you take things too far. I think we have current statute in place to protect public safety and welfare, and I would support leaving it as things are.
Senator Erickson.
Thank you, Madam Chair. I'm not an attorney, admittedly so, but I'm looking at Section 2. Can someone kind of walk me through, if I'm understanding this in practical terms? So the county can issue the demolition of a nuisance or something and charge the property owner for the cost of that demolition or whatever takes care of the nuisance. Do they have to get so many bids on that? Can you kind of walk me through, sorry for the feedback, can someone walk me through kind of what that looks like, and then the process of appealing the property value if the cost of taking care of the nuisance exceeds the property? Can someone kind of walk me through that in layman's terms? Thank you, Madam Chair.
Who's going to walk through the process here? On the WebEx? Somebody address Senator Erickson's question?
Would you like me to do so, Madam Chair, or?
Anybody that wants to address Senator Erickson's question, please.
Madam Chair, Chris Labrum here. I'm happy to address that if you would like.
Yes.
Thank you, Madam Chair. So again, Chris Labrum, Metro Area Building and Construction Department. So Senator, the nuisance code that we have in place currently defines the nuisances. So those are well defined. We have 13 items that meet the nuisance criteria. So that this will not change our process in any way. Those would still go forward through just as they are set forth now. So what this would do is add that at the end of that process, which would include a conviction from the court, that in those extreme cases, note that the bill does say those that pose a menace and danger to the inhabitants of the county would allow then the chance with another BOCC directed action to go remove those nuisance items. So and yes, that cost would be assessed back to the owner. That would also be where this is enabling legislation that we would have to establish again an abatement code that would go with our current nuisance code that would be the governance for this. But yes, you would have a situation in which action we took would potentially, well, as the process would likely go, they would be given the chance to pay for that charge. Of course, if they were going to clean up the nuisance, that probably would have happened anyway. And then from there, it is assessed to the taxes of that. If I could just quickly, for example, because there's been discussion of the KDHE and some of those pieces, in the examples we gave, the second example there is probably my most extreme case right now. KDHE does have a case and has a violation on that property. They came in and removed a great deal, actually, of human waste that was being stored on the property in 5-gallon buckets because that had a potential for groundwater contamination. After that, they turned it back to us and said it did not rise to the level. They consider it, even use the term more of a run-of-the-mill nuisance. It doesn't rise to the level then of their continued involvement or intervention. So most of that still just sits. It has been that way for several years. And unfortunately, in an abandoned status now, just it continues to pose a hazard to those neighbors there.
Senator
Hopefully
Francisco.
that helps.
Yeah. Did you have a follow-up? I'm sorry. Okay. Senator Francisco.
Thank you, Madam Chair. I do have a question for the representatives from the county, but first would make a comment that simply annexing the property to deal with this puts a significant burden on those property owners, because if they haven't chosen, they would now be paying city taxes, and perhaps doing that without adequate or the same kind of city services. But the question I had was, I know that the county has an agricultural exemption in your zoning code. There's an agricultural exemption in the zoning code. And I'm wondering, since that exemption is for land and buildings used for agricultural purposes, does that extend to grain elevators?
That would be correct, Senator. So we have in our zoning code, our current nuisance code, as well as the abatement code that would associate or would go with this bill, which also includes that. We have agricultural exemptions in all of those.
Thank you.
Senator Warren.
Thank you, Madam Chair. To follow up on Senator Erickson's question, is it correct then that nothing in the bill itself determines how the county would assess what the cost is to abate the nuisance, and that would then be left to the county to create and enact an abatement code? And that's maybe a question for the revisor or for Mr. Labrum?
That is correct from our perspective, Senator.
Thank you. And does the revisor concur?
Yes, that's correct.
Thank you, Madam Chair.
Senator Erickson?
Thank you, Madam Chair. Just bottom line here, at any point during this process, could the county take the property due to lack of payment for the cost of the abatement? Thank you. Thank you, Madam Chair.
And ma'am, Chris Labrum again, no, we could not. So again, cost of abatement could be assessed to the taxes. Now, if property taxes, not assessment taxes, are not paid over a period generally of 5 years, has been the current policy in the county, then the property could go to tax sale. Once a tax sale is complete, any revenue from that sale beyond what pays the property taxes will pay towards the assessment to help pay off the assessment. But they would again be very separate actions. That would only be property tax payment.
You have a follow-up? Senator Erickson?
I just want to make certain. So as long as the property owner is paying the property taxes, that land can't be taken due to not paying the cost of an abatement. I just want to make perfectly clear.
That is correct. And that all goes through completely separate. So that is appraiser's office, legal, that completely separate processes from me. I have no influence in any of those.
Senator Thompson?
Just real quick, are most of these properties you're talking about that you're dealing with, are these mostly abandoned or are they occupied? Just curious.
It is a mix, Senator, and some of them we've had problems with for several years and then have become abandoned. In some cases, we've had situations where an owner had ongoing nuisance situations. The owner has passed away, and so children have inherited the property and they don't really want to deal with it, and therefore they're abandoned.
That's kind of where I was going with this, whether or not we're dealing with an elderly person on fixed income that doesn't have the means to clean up their property, or if it's something where the kids have inherited and the parents are gone and that type of situation. So thank you. That answers that. Thank you.
Senator Haley?
Thank you, Madam Chair. To Senator Erickson's point, I don't know if Mr. Long could point us to where in statute there is a separation between delinquent taxes and nuisance abatement fees being rolled together for a subsequent tax sale. I respect and appreciate that might be the policy in Sedgwick County, but I've represented parties who were in tax sales, but the taxes included liens that were placed due to demolition of the structures that were on the property, and all of those costs were in the tax sale. So I don't know if it's specific to Sedgwick County that you segregate delinquent tax and lien charges, but if so, I'd like to know where that is and to ensure that we have that.
Oh, and Senator, you are correct. I'm actually looking at that right now. So let me correct my statement on that. That anything assessed to the taxes would count as the tax in whole against the taxes that are due. So that could be a portion of the cumulative taxes that would add up to resulting in a tax sale.
Thank you, Madam Chair.
Thank you, Madam Chair. And to follow up on that question, if you have a contractor who is doing the demolition work on a property, and would they be able to file a mechanics lien of some sort on the property, and then the contractor who does the demolition work could force a sale of the property? Maybe that's for the revisor or Mr. Labram.
And that, from the county perspective, no. They would not, once the contractor works for us, so anything, any damages or anything associated with that is county liability.
So the contractor wouldn't have an ability to file a mechanics lien on the real property?
That is correct. They would have no rights to that property.
And we know that because of what?
Well, that would be our intent with the code. Let me turn it again with the abatement code that we would put in place. I say that from experience as well too, since we also oversee the city portion of this, and those are very well defined in those processes. Let me, Senator, turn it over to Justin Wagner to fill in some there.
Senator, to your question on that, the if the county would undertake nuisance abatement, have these powers, and actually go through one of these, the Board of County Commissioners would have to budget funds to pay for any wrecking contractor that would come in and do the work. So they would be paid by the county. Then where the county would either retain payment from the property owner later is what would happen. So that I don't think that the contractor would have a means to go for as long as the county paid them, they wouldn't have a mechanics lien interest because they would have been
the contractor had been paid by the county and they've been paid, so
That's
there's
correct.
no lien to file. Okay, got it. Thank you. Thank you, Madam Chair.
Other questions or amendments? Senator Francisco.
Thank you, Mr. Chair. Ms. Chair. I have an amendment, and I'll pass it out. It has to do with identifying that exemption for agricultural uses.
Just take one for you and Elise, and Noah will get her around.
Madam Chair, we had some discussion about the exemption for agricultural uses and how that might be best proposed. So in talking with Commissioner Jim Howell, who testified to us on this, my understanding, and I have now a copy of the Sedgwick County zoning code, that the zoning code in Sedgwick County must exempt agricultural land because in fact the state legislature does not let counties zone land agriculture. So they have an exemption that the code does not apply within the unincorporated area of the county to the use of land for agricultural purposes or to the erection or maintenance of buildings thereon. And this goes to also include residences that are part of that farmland. And I will get this to our committee assistant. But this amendment would focus on that area. So I think it would make it very clear what areas of the unincorporated part of Sedgwick County are affected by this nuisance ordinance and which are not. Because this exempts any area, or it just says that nothing shall apply to any area that is exempted from the Sedgwick County zoning code as part of any agricultural exemption provided by such code. So when I was talking to individuals about, what was happening at a farm or a ranch, they indicated that there would be buildings, but there also could be an old tractor that you're using for parts, or a pile of metal that you might be wanting to use to repair things at the farm. This includes all of that because it focuses on an area rather than an activity. I was pleased to hear that the county does indicated that grain elevators would be part of their agricultural exemption. So I'd stand for any questions.
Any questions? Okay, Senator Warren.
Thank you, Madam Chair. Just a question probably for the reviser. Are grain elevators often in zoning codes under commercial or industrial and not agricultural?
Chris or Justin or Jason? Maybe they're looking. Senator Francisco, while they're looking for that answer.
Yeah, thank you, Madam Chair. This amendment that I'm proposing is directly to clarify the area rather than used for agricultural purposes. It may work for the grain elevators. I think we would have to, or want to make sure that it does before we pass that. But the intent of this amendment is to just more clearly identify the areas that are in the exemption because of agricultural purposes. And I think it does it more directly because it refers to a specific area.
Mr. Stuckey, I don't want to put you on the spot. I'm going to take some other questions, but could you respond to this question, please?
Thank you, Madam Chair. And we appreciate the careful read and the offer to amend. Just so everybody's aware, grain elevators there's on-farm storage, smaller generally than the large commercial cooperatives that you see in most cities and counties. And those commercial grain elevators are going to be mostly zoned as industrial properties versus the on-farm storage, maybe smaller grain elevators that would be grain bins that would be for agricultural purposes and zoned as agricultural properties.
Thank you. Senator Haley?
First, Madam Chair, could Randy please identify himself?
Oh, I'm sorry.
Thank you.
Randy Stuckey, Kansas Grain and Feed Association.
Thank you, Senator Haley.
And thank you, Madam Chair, and thank you, Mr. Stuckey. My question, I guess, was more, though, for Senator Francisco, very briefly. I don't know, I'll support the amendment, but in the old tractor is mobile, does this not defeat the purpose of wanting to clean up a particular area? If there truly is a problem, everybody could just put the old machinery, since it's not a fixture like the old barn or the silo, put a whole bunch of old tractors there, and then you have a nuisance for the area, or the eyesore that I think you're trying to abate.
My understanding from the testimony from the county and their information that they've given us is they're trying to abate particularly areas that would be zoned rural residential or residential housing, not anything connected with agricultural activities. So they've been very clear that they do not intend for this ordinance. So if all the tractors got moved onto a farm out of the neighborhood, maybe that's a good thing.
So I just want to make sure I understand. Senator Haley, are you making a comment that tractors are a nuisance?
Her testimony, Madam Chair, was that the old tractors, some that are just used for parts, and we've seen them before.
Ours is used for a Christmas ornament, but go ahead.
And I would never consider that a nuisance as long as it's able to be lit up. And I've seen some of those like that that perhaps need to be painted, a little rusty, but they're rustic in there. So I just don't know of a few of them beyond yours, Madam Chair, which would never be considered a nuisance. But if the others were brought onto the property, wouldn't the neighbors or wouldn't the area, because it's exempted, because it's ag, are you really solving the problem that perhaps they want to solve in the first place?
I think we're getting outside the parameter of the intent of this bill when you start talking about tractors.
I didn't bring up tractors. I'm just replying to something that, I mean, in terms of equipment and machinery, I didn't mean to offend the.
That's okay.
Tractor or machinery.
Right. I am a property owner, so. We're going to wrap up because I know people have to get to another committee. We're going to go to Senator Falscadell before we do.
Thank you, Madam Chair. So, Senator Francisco, your amendment, did you discuss this with county commissioners and Cedric?
I discussed it with Mr. Howell, who was the county commissioner that testified on this bill. And he was supportive of the concept. He shared with me their zoning code, and I have sent him this amendment, but obviously not in time for him to comment. But I think it is a very direct way by what we're looking at. And then if someone in a rural residential area said, oh, this trash is to keep my chickens warm in the winter so that they can bury in it, then it eliminates some of the opportunities to get around, I hope, the nuisance ordinances.
All right, committee members, we're going to take this amendment up on Thursday. That's where we'll begin on this bill. Thursday, we have the, I want to call it the cemetery bill, but it's, do you know what number that is? Anyway, you'll, which one? 97. We'll have a hearing on it. Tomorrow, you are in this committee, Senator Bowers will be chairing the meeting on a fee board, so we'll be having a little bit different structure tomorrow. We'll see you all then, and we'll talk a little finance first. So this meeting is adjourned.